Thank you, everyone. Please be seated. This afternoon, we are here for two oral arguments. The first case is State versus White, and it looks like the parties are ready. So, Ms. Regenold, did I pronounce it correct? Okay, thank you.
May it please the court, counsel. Article 1, Section 10 of the Iowa Constitution requires face-to-face confrontation, which Section 915.38 violates. The Iowa Constitution was ratified in 1857. Only 11 years later, this court in State versus Reinkoester interpreted Article 1, Section 10 to require the defendant the right to see the witnesses against him face-to-face, which was reaffirmed 2 years later in State versus Collins. This is important because this helps us understand what the framers of our Constitution thought confrontation meant. But it was about 45 years later in State versus Brown where this understanding began to be eroded as this court adopted Sixth Amendment analysis as opposed to continuing to apply or interpret the Iowa Constitution independently. We should return to that understanding of the Iowa Constitution requiring face-to-face confrontation. So what State versus Brown did was it adopted the analysis of Maddox versus United States from 1895. And that case is problematic for a couple of reasons. First, it relied on Professor Wigmore's understanding of confrontation. And I think the academic literature shows that while his thoughts were once esteemed, they're less so now. For instance, Wigmore believed that face-to-face was dispensable, whereas the authorities he relied upon said the opposite. They said both cross-examination and face-to-face were necessary for confrontation. Maddox versus United States also brought in that necessity and public policy language that we see used in Maryland versus Craig. It didn't cite to any authority for that, but of course it's the US Supreme Court. They can do that. But what is important about Maddox as well, and Brown, because it basically adopted Maddox, is that it essentially aligns with what Crawford says now. Now, Maddox was different from Crawford in that it involved a deceased witness who'd formerly testified and was no longer available at retrial. But what it held was that the defendant got his confrontation, he got cross-examination, he got face-to-face. And the death of the witness shouldn't prevent him from going to trial again. So Brown then took that a little bit further and said that it should also apply when the witness was out of state. So in Brown, the defendant had previously had a trial where, again, he was afforded cross-examination and face-to-face confrontation, but the witness was now in Hot Springs, Arkansas, and according to the Supreme Court, that meant he was as good as dead or across the ocean. And that was because, of course, travel in 1911 was far more cumbersome than it is now. So we've talked about what's problematic with Wigmore. We've talked a little bit about the history. There is also that tension between Crawford and Craig that I've referenced in my brief. And how do we reconcile those for this court to reach a decision? As I've argued, I don't believe the court should follow the Sixth Amendment analysis under the Iowa Constitution because of the state of confrontation jurisprudence in the US Supreme Court and the federal courts. We see that the lower courts are struggling with how to apply both Crawford and Craig. There is this uneasy tension between them. And so to avoid that, we should avoid the Sixth Amendment analysis. Now, both this...
An argument that can be made that, in 1857, child sex abuse cases were pretty rare if they even happened at all, that children, that children generally did not testify in court, and that therefore Article 1, Section 10, as it applies at least to children, isn't necessarily something that we need to take on here.
I disagree, Your Honor. I think if we dig deeper into the academic research about children testifying, it's not as clear-cut as that. I would agree with you that, from my understanding, child abuse prosecutions and sex abuse prosecutions were perhaps more rare then than they are now. However, if we look at the article on the history of child testimony that's cited in Ray JC, if we dig a little deeper, children did testify on occasion. Now, sometimes that changed there were a few factors. One, did they understand the oath? If they didn't understand the oath, there was some opinion that they could still testify, or alternatively, that a parent or other adult would testify to the statements that child made. But children did still testify, and also that article talks about very young children. We do not have that here. They were 8 and 11 at trial, respectively. So I don't believe that analysis applies here. But also, if we look at the research, it also says that there was a high acquittal rate of those. Again, that article was specifically about sex abuse, not child abuse, as we have here. There was a high acquittal rate. About 86% is what the article said about where children testified or there was hearsay testimony. Now, part of that, we know, is the proof required for a sex abuse at that time, which is not the level of proof we require now. But part of it is the judges would also admit that testimony or the hearsay, but then tell the jurors they could not rely on it. So I think it's a little more nuanced than what we've seen in Ray JC, if they're admitting it, but then telling the jury they can't rely on it. And that's not entirely clear from the record that we have of those cases. But I think because of that, we need to consider all of that in deciding this case.
Did you say the kids were like 8 and 10 or 8 and 11 and not really so young? Was that what you said?
Young, as was discussed in the academic research.
Qualify under Iowa's statutory definition of child.
Yes, Your Honor. They're children, but they are not very young children.
I guess we're splitting hairs, but in Iowa's definition, a child is under 12, I believe. 12 and under, okay. I just wanted to make sure I was understanding that you weren't trying to say that they were no longer children.
No, they are children, certainly, but for instance, in Ray JC in Ohio versus Clark, they talk about the opinions talk about very young children, and I think that is different. I think we would all acknowledge the abilities, and this may have been a factor in decisions in the common law era, not only the inability of a very young child to comprehend the oath and its impact on their testimony. There is also the limited language ability, the limited ability to give a narrative about what happened. All of those may be factors with very young children, but they are not applicable in this case.
Counsel, are there any states that, under their own constitution and setting aside states that have an express face-to-face in their confrontation clause, are there any other states that have a confrontation clause similar to the Sixth Amendment who have decided under their own constitution to impose a strict face-to-face requirement?
Not that I'm aware of, Your Honor.
Obviously, the technology, the video technology that we use in lieu of the face-to-face confrontation, that didn't exist in 1857, right?
But as this court acknowledged in Rogerson, the technology, even with what it is today, is not the same as face-to-face confrontation.
And did this involve one-way or two-way? One-way, okay. And does that make a difference?
It does, because the witness cannot see my client. And that was even more problematic in this case because the statute requires the judge to tell the witness that that the defendant will see and hear them from the courtroom. This judge went a step further and saying, now you don't have to see him when telling that to the first child who testified. That nullified any effect of the cautionary instruction that the court gave in advance of the witness's testimony by saying, now you don't have to see him. And also, we know that juries speculate. When a witness doesn't appear in court, there's some speculation. With young children, there may be the assumption that they're uncomfortable with the courtroom. But here that affirmed that these children were too frightened to testify in front of their own father, which is prejudicial to Mr. White, when he's on trial, not for abusing them, but for abusing another child.
They'd been in the courtroom too, right? If everybody been in the courtroom, you don't dispute that, right?
The courtroom, yes, or if they're nervous, if they are in fact frightened of Mr. White. But then the court wouldn't say something like, well, now you don't have to see him, which then affirms the court's view that this child is frightened of Mr. White, and the jury did not know that.
So what do you think about, let's suppose that we went your direction on this, and the state is saying, though, that there was strong and persuasive evidence and that we could find harmless error here, in part because defendant was the only person with means and opportunity to inflict the injuries, and I guess a belt owned by the defendant was used. What's your response?
Your Honor, because there was conflicting testimony about when Reinkoester and her adolescent child left the house. So they'd gone out of town. She took him to live with his grandparents in North Dakota. There was conflicting testimony about when that occurred. And so that suggests that there could have been some confusion about when that actually occurred, that she could have been home or the teenager could have been home that could have inflicted this injury, as well as a belt found, yes, in his bedroom, but could have been used or worn by others in the household. We know that Ms. Reinkoester had other gentleman friends that were involved in her life that could have left a belt as well. So when we're looking at harmless error, we have to look at it without the evidence of those children, and there is not enough evidence, even without, with what you've said.
Those two witnesses testified about that the father was a disciplinarian and the mom was not. Was there any other evidence when you take that testimony out, addressing that point, just who was a disciplinarian?
It's also problematic that both the Court of Appeals and the state relied on State versus Strabel, a decision of this court. In my view, nobody should be relying on Strabel. It would not have survived Coy, it would not have survived Craig, because it involved an accuser testifying with a blackboard between herself and the defendant. And in that case, she testified that it would be embarrassing or difficult for her to testify in a face-to-face confrontation, which would not meet the necessity requirement of Maryland versus Craig. Strabel also relied on Wigmore, which is problematic for the reasons I've already stated. And it was also a bench trial, so that doesn't change, of course, the defendant's confrontation rights, but it does change the prejudice, and that's why the court found harmless error in that case. Furthermore, Strabel was decided under the Sixth Amendment. It only made a passing reference to the Iowa Constitution. The state also made the point about there being no exceptions in this requirement of face-to-face. And as we know, case law evolves over time. While I don't believe there are any exceptions here, there may be exceptions decided in future cases, but also as acknowledged in Maddox versus United States and State versus Brown, we look at exceptions that were available at the time of the founding. And in that case, they referred to the dying declaration as one that would be an exception that would be available.
Have a new technology, I mean, don't we have to say, maybe engage in a thought process and say, how would this technology have been viewed at the time if it had been in effect, or something like that? I mean, much as we do with, say the Fourth Amendment cases involving the cell phone or the GPS tracker, we try and think about how that technology or the equivalent of it would have been viewed at the time. It's a difficult exercise to do, but don't we have to, at least engage in the thought process and not just say face-to-face, end of story?
It is difficult, I'm sure, to envision what our framers and founders would have thought of this technology, but I think that's laid out again in Rogerson, that it is not the same. We see that in this case where there was some problems with being able to hear one of the children Now, of course, we all know in a trial courtroom that can happen as well. You may not be able to hear a witness. And so then the judge will say, could you scoot forward? Could you speak into the microphone? Here it's more disruptive of the child's testimony because then the court attendant had to leave the courtroom and go to the other room and say, let them know and interrupt the proceedings and say, Judge, we had to turn off one of the mics. We can't hear you. And then they had to repeat some of the testimony. So there is the technological difficulty, especially if we have the two-way virtual. We have the, if I may finish, Your Honor, I see my time has expired. Technological problems that we all experience with the amount of time we've spent on Zoom and other platforms recently when the internet causes some disruption that can, and there's also what we recognize, what our framers recognize, what Rogerson recognizes, the indisputable social pressure of a person meeting you face to face, having to, now they don't necessarily have to look you in the eye, but they have to be in your presence and accuse you of something. That is very different when you're in a different room, perhaps in the courthouse or not even in the courthouse across the country if that becomes allowed. There's a very different experience of having to accuse someone. And we also have concerns about being able to, if you're in a two-way situation, we have concerns about coaching, especially with young children. That's always a concern that there could be coaching, that if you don't have that presence, are they being coached? Thank you.
May it please the court, counsel? In 1989, this court squarely answered the question presented by defendant today. In interest JDS, a defendant claimed a confrontation clause violation when the district court allowed a child witness to testify behind a one-way mirror. His counsel claimed this was a violation of the federal Constitution and the Iowa Constitution. This court said in that opinion, by enacting Chapter 910A, the Victim and Witness Protection Act, the legislature evinced its belief that protection of child witnesses is an important public policy. The trial court found, and by our de novo review, we agree that the screening procedure employed in this case was necessary to protect Brad and comported with the statutory purpose. We also find the procedure to be reasonable and hold that it did not violate Jay's right of confrontation under the federal or Iowa constitutions. So this is not an issue of first impression. This has been decided. And I think what's very interesting about this case too is that this is a pre-Craig case. Post-Coy, pre-Craig, this court determined that that procedure it passed muster under the Iowa Constitution. And in fact, the Maryland court cited to JDS in the Craig cases on its way up to the Supreme Court. So I think if we're gonna go all the way back to history and framers' understandings, this preparation for this led me all the way back to the territorial laws of Iowa because I was curious if there were any mentions of the Confrontation Clause in the territorial laws, because there isn't in the Constitutional Convention. And what I learned from the territorial laws is that there's no mention of trial rights at all. And this led me to think, is this because we were governed by the federal Constitution at the time? And we were. We were a territory that had to follow federal laws and the federal Constitution. And so I think that in the Constitutional Convention, when our framers and founders decided to wholly adopt, word for word, the federal constitutional phrase for confrontation, they intended it to be the same. And I think, can infer this from the fact that they made other material changes to Section 10, Article 1, Section 10.
If we were analyzing this sort of strictly under a federal standard, I might agree with you that I think Craig has not been overruled. But Roberts, it seems, has been, at least as to testimony. And there's been, and you've read it and you've cited it, a lot written about what is sort of left of Craig after Crawford and how a court should analyze that. And so, if we were to follow Craig it strikes me that we would then have to reconcile Craig's reliance on this balancing test in Roberts that is no more.
So I disagree for two reasons. One, I don't think that there are a lot of courts that find that Craig did not survive Crawford. I think perhaps what I've seen is maybe 5 or 6 courts, occasionally in concurrences, have expressed some tension. But there certainly is no one who has deviated, and I don't think there's any sort of overwhelming amount of courts who think that this has happened. And I also...
Michigan?
Has Michigan deviated? I don't believe so. It's just Illinois and Pennsylvania, I thought, because of their state constitutions, but I don't think from the federal, because of that from the federal, but I could, that's not my understanding, but I push back on the idea that Craig so wholly relied on Roberts that it cannot survive. And I also think, and I think this for two reasons. First, in Craig, they don't pull that test from Roberts. Roberts is mentioned in that opinion, but not greatly. They also rely on, these are the cases that I've pulled out from the older Supreme Court cases that are more relied on in Craig. Coy, Stenser, Green, Kirby, Maddox, Dutton, Lee, Finster, and Allen. These are all good law, and no one has suggested otherwise. And one of the other reasons I think that the overruling of Ohio v. Roberts doesn't really matter for Craig is because the Supreme Court basically said it in White v. Illinois, because in that case, that was more of a then Ohio versus Roberts, but now a Crawford case in determining whether hearsay could come in. And in that case, the defendant tried to rely on the necessity part of Craig and Coy to say that child witnesses' hearsay could only come in if it was necessary. And the US Supreme Court said that the petitioner's reliance was misplaced, that Coy and Craig involved only the question of what in-court procedures are constitutionally required to guarantee a defendant's confrontation right once a witness is testifying. Such a question is quite separate from that of what the requirements of the Confrontation Clause impose as a predicate for the introduction of out-of-court declaration. Coy and Craig did not speak to the latter question. So I think there are two lines of Confrontation Clause cases, really. There are your Crawfords, what has to be met before an out-of-court statement can come in, and then there are your Craig cases. What are the procedures that can be employed for in-person, testimony? And so I think the Supreme Court's reliance in Craig of all of the other, of the history of the Confrontation Clause shows that there has never been an absolute right. It has never been determined that this is literal and absolute, that it always gave way to public policy, especially the public policy of finding the accuracy of the process, of the trial, that if that was impaired, that it could be deviated from. And that's exactly what we have here. We would have an impairment.
There's any difference at all between the closed circuit television testimony and in-person in front of the jury testimony?
Is difference. But the question is whether it's such a difference that would mandate it. And I just don't see that there has.
Just two-way.
I actually find the question of two-way versus one-way to be very distinct from each other. Because two-way really is, you would still probably see the defendant, right? It would just be through a screen.
Involved one-way, right? So so that's my point. I mean, doesn't that make a bigger difference at least than if it was two-way?
The whole point of the one-way television is so the child does not have to see the defendant. But the child still knows they're testifying at a trial. They still know the defendant is watching.
Do you think it's possible that somebody who doesn't have to look at their accuser might present themselves in a way that's more confident, more assertive, and maybe in a way that's different than other witnesses who have to appear in a courtroom and sit in front of jurors and sit in front of the defendant?
Children? No, I don't think so. Perhaps for adults, maybe, but I don't think for...
Point, there has to be a finding of not only trauma, but impaired communication. That's Scalia's point, is the reason you're accepting this, or the public policy rationale for this, means that the witness's testimony is going to be materially different if the witness doesn't have to see the defendant.
Thinks that, but he was a dissenter. That's not the majority view.
They said that's the reason why you have to prove the testimony would be different.
I mean, the interpretation has always been a preference for face-to-face, but not an absolute requirement. And part of the reason we have these procedures is to ensure the reliability of the trial process because of the high likelihood that the victim would not.
Element to invoke the exception is that the in-person testimony has to impair the witness's ability to communicate.
Right, and by.
Is by necessity from the test different in quality when the witness can't see the defendant and when the witness can. I don't see how you can say that's not a difference.
And I didn't mean to imply that. But what I'm saying is that it actually makes the testimony more reliable, not less. This isn't a case of someone coming into the courtroom and being unable to testify because they are lying. This is someone coming into a courtroom, a child coming into a courtroom who is unable to testify because the person who did this to them, they're so scared, they're so traumatized that they cannot actually testify. And I have to imagine that our founders did not mean to give defendants that kind of trump card, that we would just wholly stop prosecuting these types of cases because a child would be unable to come in and say, my father beat me, my father raped me, et cetera, et cetera. And especially because that would mean the more heinous the crime, the more likely the defendant would be to get away with it. Because the more traumatized the child would be, and essentially we would be at a point where maybe we couldn't even prosecute these cases. And I do not think that that was what was anticipated.
It relates to all criminal prosecutions. There's no distinction between degrees of crimes and the trial process that the framers selected for adjudicating guilt. I mean, you keep saying the things the child suffered, which assume the allegations are true, right? And you're also assuming that every witness is truthful. And the whole point is we determine truth by a certain process and not assume truth and assume guilt and then re-engineer the process after we've made those fact findings.
I don't think we're assuming truth. We're ensuring the reliability of the procedure, which is what Crawford reinstated, of how this evidence comes in. And I think if we are looking back to Ohio v. Clark and what this court recognized in In Re JC, is that, first of all, I have to go back to saying that the federal Constitution has never been interpreted in that absolute literal way. There are case after case saying that has been wholly rejected. But going back to the idea that I think history has embraced the idea that sometimes we do treat children's testimony differently. That we have the cases, from pre-federal Constitution where children were sometimes brought to court as witnesses to determine their competency. If they were competent, perhaps they were able to give the testimony themselves. But if they weren't, their parents were permitted to come in and tell the court everything that the child had said to them. Or they were able to give unsworn testimony, which of course would be very different from today. So, I mean, I think that those procedures show that courts have long recognized that children are fundamentally different than adults, and that it does not violate a defendant's right to a fair trial, to confrontation, to examination, to sussing out the truth, that we treat that we give them a slightly different procedure.
Questions about, let's just assume we disagree with you for a minute. I guess one issue that comes to my mind is it seems like there's, when we're talking about possible prejudice of this situation, just looking at it, the fact that we put the defendant out in the courtroom and we completely separate them from these witnesses seems to speak of it seems to suggest the guilt of the defendant inherently to me, or at least some sense on the part of the court that the defendant's dangerous to these children. So I worry a little bit about the prejudice from that aspect. Even putting that aside, these were extremely important witnesses to this case, and So if we disagree with you on this point, it's a new trial. Wouldn't you agree?
They provided important testimony, there's no doubt about that. But I think if you're looking at the elements of the case and the testimony that came in, it is beyond reasonable doubt, beyond a harmless error, that this defendant did this crime, that he was the only one in the house on the timeline that's provided by the witnesses who could do this, and that his belt was the one that did it as well. It wasn't just that he had one belt. The officer went in and looked at several belts and found the one that matched the injuries. So in that sense, I don't agree. But I also want to...
And from your point of view, then, in terms of getting this conviction, that these children's testimony really wasn't necessary.
You would have found him guilty without it. Or the jury would have found him guilty without it. I think you could look at the evidence and see that.
And this is one of Scalia's points, that if we're talking about protecting children, if the state has such a great case that they could have gotten a conviction without the children, and then instead the state decides to go forward with the children, isn't it sort of the prosecutor's choice to not, to possibly protect or not protect the children by putting them through this process?
Sure, but that doesn't mean that their testimony still isn't. That's the prosecutor's decision, and they can decide to try their case the way they want to under the procedures that are
On the stand in front of him and have quite a commotion that could be detrimental to the defendant as well. I mean, whether you put them in another room or put them there and let them melt, there's a balancing, I think.
agree. And could I just have one moment to say something very quickly, Your Honor, to finish up? I just want to say very quickly that this claim was not preserved. You can go back and read the trial court's ruling, and in nowhere in that ruling does it say anything about this test, this ask, any of it. That's because the defendant didn't ask for it at all. And so we shouldn't even be reaching the merits of this case because it was never, this test, this ask now, was never made to the district court. And the district court didn't understand that to be the argument the defendant made, and it did not rule on it. So at this point, I know it's somewhat, anticlimactic to come to the Supreme Court and say you're out on error preservation, but it's not preserved. And so I would find that the court find that as well. Thank you. Go ahead.
Two, McDonald and May. Go ahead.
Looking at page 3 of the defendant's resistance to the motion for protective order, the court, it says the court should follow an even stricter approach under Article 1, Section 10. The court should follow the reasoning of the dissenters in Craig, Scalia, Brennan, Marshall, Stevens, who reasoned to confront plainly means to encounter face-to-face, whatever else it may mean in addition, and more of that. And goes on to say, at the very least, Article 1, Section 10 requires in-person, face-to-face testimony of non-victim witnesses. So it was presented.
I don't read it that way, and neither did the district court. Because especially in the oral argument at the hearing, the defendant really made two arguments. He argued that these children should not qualify because they were not the victims of this crime, that we should not read them to be allowed. And then he said that Craig actually required a more stringent statutory finding for necessity for the children to testify outside, and that the court should follow that approach. And if you go to page 5 and 6 of the district court's ruling, that is exactly what they rule on. There is no ruling or understanding that this broad argument was made. Thank you.
You have a question based on that? Or was that the question? Okay.
My question. I want to talk to you about Cry and Mathis. And in Cry and Mathis, we're dealing with jury instructions and the non-corroboration instruction. And the rationale in that case is we had a particular concern about trial processes, including instructions that created asymmetries between one witness's testimony and another witness's testimony. And it seems to me that some of that rationale applies here because you have a bunch of witnesses that come into court and are treated one way. And then you have a different category of witnesses that are treated in a different way. And maybe it's a different issue if everybody testifies remotely. But it seems to me that the logical thing for the jury to conclude, just like we found in Cry and Mathis, is that there's something particularly weighty about these two witnesses' testimony, or something particularly bad happened between the defendant and the witness. So address that Cry rationale and how it applies here.
I believe in every case, and I'm pretty sure in this case, the district court issues a cautionary instruction to the jury that they should not infer anything that is different. And so, we presume the reliability of those types of cautionary instructions and the jury taking that to heart. And also, the jury and the defendant remain in a room together. So, they're in the courtroom to someone separate. But also, I think that's different because, when you're sending back jury instructions and you're having them, it really points to what, you're saying like those cases point that you should maybe more heavily look at this or more heavily consider it. And I don't think that necessarily equates with someone testifying outside of the courtroom. I mean, people could testify outside of a courtroom for a variety of reasons. I mean, we've seen that, in Rogerson. There are lots of possible necessities that could have someone testify outside of the courtroom. And I don't think there's been any indication from the cases or from the academic literature that juries place more weight on children's testimony outside of the presence versus inside of the presence of the defendant. Thank you.
Back to Ms. Regenold.
The jury was given a cautionary instruction, which the court read right before the younger child's testimony. It was one crafted by the defense. It's at page 39 of the appendix. But two problems with that. One, as I said, right after that, the judge told the younger child, but you don't have to see him, which is not part of the statutory language required, which I say adds prejudice to this. Also, there was a cautionary instruction in Coy versus Iowa similar to this, and still the U.S. Supreme Court found there was a violation. So the cautionary instruction does not save this case.
Could I direct you back to the error preservation issue that I was just talking about with your friend? So I'm looking at page 6 of the district court's order now, and I don't see any mention of Article 1, Section 10 either. And I wonder how we can be assured that the district court ruled on the objection.
Pointed out, you helpfully pointed out the section I was going to point out in the defense's resistance. So on page 5 of the ruling, the court first says that it rejects, after having an opportunity to review the relevant case law, the court declines to adopt defense counsel's stricter approach. And then on page 6, as you said, it finds that this court has upheld the constitutionality of that code section. It does not specifically refer to the Iowa Constitution, but says that this court has upheld the constitutionality. And I would argue that that means that error is preserved in this case.
The district court then went on, though, to say that Iowa Code 91538 provides that the court may protect a minor witness and does not require the minor witness to be a victim. But even if it did, these two individuals are victims. What is your response to the state's position that on the specific issue of, was the argument limited to the fact that these two kids were not actual victims?
No, Your Honor, that was part of the argument raised below. Defense counsel raised a few arguments below, only one of which we have renewed. And he did indeed argue that they did not have to be victims of the offense, which the district court found the opposite. So no, by rejecting the stricter approach and by finding the statute was constitutional, the error was preserved here by the court's ruling. I also wanted to get back to a couple more points. One, the state emphasized the heinous nature of the crime, and the U.S. Supreme Court has mentioned more than once that the more heinous the crime, the more constitutional protections a defendant needs. So when a defendant is on trial here for abusing a 2-year-old child and his own children are witnesses, he needs the constitutional protection that the Iowa Constitution afforded him, which was face-to-face confrontation. Furthermore, the state talked about how bringing the children in face-to-face makes their testimony unreliable. But there's also a lot of analysis that how we question makes testimony unreliable, particularly with children. So by that rationale, are we going to eliminate cross-examination or direct examination? Are we just going to let children come in and speak free form and give their narrative about what happened? Or are we going to circumscribe how attorneys question children? We know when they're forensically interviewed, there are certain ways that children are questioned, and we saw, at least with the state in this case, they followed some of that. Like with young children, you shouldn't give them either or because they'll pick one, so you try to give them a list. So if we're saying their testimony becomes unreliable because they're testifying in front of the person they're accusing, then again, where are we going to stop?
In my trial court days, and the times I had to make the very decision that was asked today, I was weighing everything, the child's best interest as well as the defendant's rights. And when I made a decision for them to be in another room, closed circuit or whatever, I don't know if I can ever prove it, and I hope nobody isn't put in that spot. But that child that I was dealing with, like I think this case was, the risk you run, and I'm wondering what the defense would be saying when all of a sudden they, like I said, melt in front of the jury, cry in front of the jury, scream in front of the jury, say things. I imagine that's also going to be something that the defense is going to complain about. So can't we give some credit and some thought to what the judge went through in weighing what's worse? These children have apparently persuaded, the court's been persuaded they've been traumatized. Isn't there a major risk that trauma also will explode in the defendant's face, and that could impair his right to a fair trial?
More likely children, yes, but other witnesses do implode as well. That does happen. But frankly, I'm not concerned about the court and that they're weighing. I'm concerned about my client's rights and the constitutional rights. And this court, or this statute, allows a victim's statutory rights to be elevated over a defendant's confrontation or constitutional rights, which is in defiance of everything we all learned from the first year of law school on. And so for those reasons, we would ask this case for this court to reverse and remand so that my client can be afforded his face-to-face confrontation rights. Thank you.
State versus White is hereby submitted.